I do. For everyone on the phone, I'm Kathleen Trevor, and I am Deputy Attorney General providing legal counsel to the Commission and the Department. First, let me just, for way of background, restate that the goal of the Commission has been to achieve full state management of wolves and to remain ready, willing, and able to manage wolves so delisting can occur. And in the meantime, the Commission's goal has been to address the impacts of wolves using 10J and other legally available tools consistent with the direction of the Governor. With that background in mind, I also wanted to just remind everyone of what we do know about the delisting path. As the Director mentioned, Idaho and Montana have state management plans approved by the U.S. Fish and Wildlife Service. That is the 2002 Idaho Wolf Conservation and Management Plan approved by the Idaho Legislature, and the 2003 Montana Final Gray Wolf Conservation Management Plan. Approval of those two plans allows the states to take actions under the 2008 10J rule. That's what gives Idaho Department of Fish and Game the abilities to submit proposals to U.S. Fish and Wildlife Service to address unacceptable impacts to ungulates under the 2008 10J rule. And as a reminder, court rulings have not found fault with either the Idaho or Montana plans. There have been two delisting rules, one in 2008 that included Idaho, Montana, and Wyoming, and one in 2009 that included only Idaho and Montana. The 2009 delisting rule relied upon the 2002 and 2003 state-approved plans, and for benefit of the Commission's discussion today, I also wanted to remind the Commissioners that the 2009 delisting rule did refer to the 2008-2012 5-year management plan, although it didn't identify that as a state-approved plan. Both of these delisting rules have been vacated as a result of decisions by Judge Malloy out of the U.S. District Court in Montana, who in 2008 he ruled that Fish and Wildlife Service was arbitrary and capricious for rejecting and then accepting Wyoming's plan. Where some of the legal challenges occur is because now there's basically a competing decision from the U.S. District Court in Wyoming, where Judge Johnson ruled that U.S. Fish and Wildlife Service was arbitrary and capricious for refusing to accept Wyoming's plan and requiring designation of the entire state as a trophy management area. So the delisting path through the executive branch will require Fish and Wildlife Service to reconcile those two competing decisions. I also want to make sure everyone's clear, because there has been some confusion in public perception, that Judge Johnson's decision was not a wholesale endorsement of the current Wyoming plan. He remanded the rule back to, or the decision back to U.S. Fish and Wildlife Service, and directed Fish and Wildlife Service to revisit and reconsider issues as to whether the proposed size of the trophy game management area was sufficient to allow the state to meet and maintain recovery goals, whether the contours of that area should be expanded to include additional portions of northwestern Wyoming where wolves are currently treated as predators. Basically remanded the matter back to Fish and Wildlife Service to revisit the matter. So I would not want people to read that as Fish and Wildlife Service has to accept Wyoming plans as is, and because it has to reconcile the decisions between the two courts, I think it would be reasonable to think that there would be changes to the Wyoming plan for Fish and Wildlife Service to accept it, but that's just my legal forecast, and that matter would be up to Fish and Wildlife Service. There are also other legal issues that would create uncertainty from the delisting perspective. As you all know, we have an appeal pending with the Ninth Circuit seeking to reinstate the 2009 delisting rule. So to the extent the Commission makes changes to things that were relied upon in the 2009 delisting rule, that would create uncertainties in terms of the status of our appeal. As you know, there is also a case pending on the 2008 10J rule that's with Defenders of Wildlife, Western Watersheds, and others. And earlier this week, there was a hearing before Judge Windmill in a case in which Western Watersheds and the Wolf Recovery Project are seeking to halt USDA Wildlife Services from performing control actions in response to livestock depredations. And the status of that case did change when Idaho handed back the management authority to the U.S. Fish and Wildlife Service. So I wanted to put all of those issues out there because to the extent there is uncertainty and to the extent the commission creates changes that may have consequences in terms of pending legal matters. I do recognize, however, that things from a factual standpoint have changed since the adoption of the 2008 plan. If the plan had been implemented, adaptive management would have been allowed to work to address those changes, or in some cases probably prevent some of those changes, but the plan has not been allowed to work. There have been increases in conflicts. There has been expansion of the geographic distribution of wolves in the Panhandle and elsewhere, increased wolf sightings in communities. And as I mentioned, there is uncertainty in terms of the delisting path. From a legal perspective, as the commission has heard before, it's better not to add additional uncertainty by changing numbers or management directions when you don't have a logical and reasonable basis for doing so. When the standard you must defend against is arbitrary and capricious, the more change and uncertainty that occurs without being able to tie it to specific facts, the more issues that can present to your case. So I wanted to review some of those items just as the commission considers what might be best at this point because of the relationship of the 2009 delisting rule to litigation and to potential legislative solutions. I would stand ready to answer any questions the commission might have in terms of potential impacts actions you're considering might have on